This evening's meeting of the Zoning Board of Appeals, we have four items on the agenda, and we will not be taking them in order. I think we'll take the 273 Autumn Ave case first, because that appears to be one that should move rather quickly. So, having said that, the Board of Appeals will hold a public hearing in the Mural Room, 878 Tremont Street, and via Zoom on Thursday, February 8th at 7:30 p.m. to consider the application of Upward Spiral Wellness. Christina, I'm going to... DeFranco, thank you. For a special permit. Yes. For a special permit under Articles 400 and 900, Sections 406, 410, 410.7, and 906.2 of the Duxbury Protective Bylaw. Property is located at 273 Autumn Avenue, parcel number blah, 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 consisting of 0.94 acres in the Residential Compatibility District and the Aquifer Protection Overlay District, and owned by Christina DeFranco. The applicant proposes to operate a home massage therapy wellness office. A special permit is required. The application may be viewed on the town's website, under the Zoning Board of Appeals page, or in the Municipal Services Department. Any person with a disability may request accommodation in order to participate. Pursuant to Chapter 2 of the Acts of 2023, this meeting will be conducted in person and as a courtesy via remote means in accordance with applicable law. Please note that while an option for remote attendance is provided as a courtesy, the meeting will not be suspended or terminated if technological difficulties arise. You may also view it on Verizon Channel 39 or Comcast Channel 9. So, we have for documents and application, with a brief description of Mr. Franco's intentions. We also have a letter from her, which I'll read into the record. Brief in support of the permit application with the Zoning Board of Appeals regarding Upward Spiral Wellness, 273 Autumn Avenue. I'm petitioning to have a small private wellness business out of the first floor of my split-level home located at 273 Autumn Avenue. I'm a certified yoga teacher and massage therapist with certificates in craniosacral therapy levels 1 and 2, Thai yoga bodywork, Qigong, and soon-to-be breathwork. Carter, my husband, is also a certified massage therapist and soon-to-be reflexologist and ancient Thai yoga bodywork practitioner. He will be ready to start taking clients in late February, March 2024. We plan to see clients on a singular basis with no more than 2 people at a time. We have a room dedicated to the spa as well as a bathroom suitable to accommodate our clients. We have ample parking in our driveway. Operating a small wellness business out of our home will have very little impact on the immediate surroundings in the way of noise or any other bothersome activity. It will, however, have a positive impact on our neighbors by adding to the healing ambiance of the neighborhood. There will be no big packages or massive increases in traffic, just the natural and healing vibes of people dedicated to their health and well-being. All visits will be by appointment only. We do want to have a small inconspicuous sign no bigger than 2 square feet. In addition, in considering our petition, I ask you to consider how a health and wellness business will be a welcome addition to the roster of small businesses in Duxbury. Ours will be a business dedicated to the health and well-being of all our residents. Thank you for your consideration, Christina DeFranco. The application includes photographs of the front and both sides of the home, a diagram of the first floor where the business will be located, and a plot plan. We also have a memorandum from the health agent. The Board of Health has no comments on the application to operate a private wellness business, massage therapy business out of the home. Massage therapy is licensed by the State Department of Public Health, not by the local Board of Health. We also have a memorandum from the Planning Board. At the meeting of the Planning Board on January 22nd, the board voted unanimously 5-0 to defer judgment on the special permit application for 273 Autumn Avenue to the Zoning Board of Appeals without additional comments. We also have a memorandum from the Design Review Board dated January 30th. The petitioner is requesting a special permit to put up a 24-inch square sign for a new wellness business, Upward Spiral Wellness. The petitioner anticipates having only a few additional cars at a time, which would not adversely affect the neighborhood. The Design Review Board has no objections to the new in-home business within a residential neighborhood. However, the petitioner would like a, quote, small inconspicuous sign, unquote, but did not indicate the location of said sign, the material, or design. The Design Review Board would request that any signage proposed be shown in more detail with exact location, materials, and layout. And I think that's all we've received, Lauren, yes?
Yes, Mr. Chair.
Well, without further ado then, why don't we hear from the applicant?
What shall I say?
you
I
have any-
appreciate your consideration, and I understand your request to see more in detail requests from me as regarding the sign, and I agree and will provide that. Just to tell you here and now, what Carter and I were thinking is just an even smaller than 1 square foot just hanging underneath the mailbox. So no, non-illuminated, very small, extremely small. But I can put that in writing and have a design and submit that and appeal again.
Okay.
But I'd like to hear from the board about being able to conduct business
Okay.
immediately. Yeah.
Jim, I just have a question about the sign. Would it be a sign that size? Would it be necessary to have some addendum to this special permit application or a separate
It is
special
a
permit application?
requirement of a home occupation to have, they can request a sign that's less than 2 square feet.
Without a special permit?
It's part of the special permit.
Part of
Along
the
with the special permit.
Okay. Less
Hey,
than
Jim, it's Wayne Dennison. The one question I had about the sign is whether it has to be in the notice. Because I did not see in the notice the request for the sign. And I don't think the ask for the sign is been appropriately noticed.
It's in the application. The request is in the application.
Yeah, I understand that.
Oh, excuse me.
Oh, Wayne, you're saying that it's not in the actual notice?
I didn't see it in the notice, which I think would make the request inappropriate at this point, but that's why I put that question to Jim.
I don't see anything in the zoning bylaw that limits our ability, or your ability to issue that sign.
So my concern is this, and I see Amy sitting there. There is a requirement that in order to issue a special permit, that you have to give notice to abutters. And to abutters within 300 feet, there's statutory notice requirements. The notice that relates to this particular special permit application says nothing about a sign. That's my concern. I don't think the sign portion of this has been appropriately noticed. But if Amy tells me I'm wrong, or if you tell me I'm wrong, I'm happy to consider that.
She will have plans.
Yeah, I know.
So no, this applies, it's really this section that applies.
How big do signs have to be for them to be permitted?
Well, any sign needs to be permitted.
It does?
Yeah.
Okay.
There's directional signs that do not need to be permitted. But for a home occupation, a residential place, this is where it gets the ability to have a sign up to 2 square feet, which was part of the application. Let me just see one thing about this.
Can I see the application? Sorry, I don't have it. Yeah, I will. Thanks. Let's see.
There, in the ceiling.
I actually think that it's fine, because it's in the application. The application, you know, the legal notice directs people to the, oh, sorry. I think it's fine, it's in the application. The legal notice directs people to the application, and the bylaw permits a sign less than 2 square feet.
Yep.
So, and not illuminated, which is exactly what she's proposing. So I think it would be fine. It is up to you as the applicant. It's a risk that you take, that someone could claim the public notice is not sufficient, but that's your risk if the board's comfortable.
Where is the location of the sign going to be proposed?
I was hoping that we could agree to hang it below the mailbox.
And that would be the mailbox
Directly
attached to the
across the-
house?
It's not attached to the house, it's across the street, and so we would have a small sign that says the name of our business.
No.
Yeah,
Nope.
not if it's not even on your land.
Yeah, no.
Okay, that's
Yeah.
fine,
It would have to, it's typically another aspect of signs are that
I understand,
typically a flush-mounted sign attached to the building.
I see. Very good. That answers that.
Yeah.
So would that be acceptable too?
That's fine,
Okay.
yes.
Does anyone else from
So
the
the
public?
410.7, which is the home and occupation special permit regulations, says the use of the dwelling is a principal location for the practice of their occupation by a person. The principal use of the dwelling is as a home, and I don't see any impediment to this request other than the sign issues. That's my view.
Quite frankly, I doubt that Carter and I will affix a sign to the side of our house. We'll probably just leave it without the sign.
So then I guess I would issue the special permit without the sign. And then it's clean.
Right, if she wants a sign in the future,
She
she
can
can
come
come
back.
back.
Yeah, you can always come back and,
Understood.
Yeah, and quite frankly, it's not gonna be very hard to come back and get the sign. It's just, I don't think it's been noticed, Rob.
Okay.
okay, well, seeing that we do have someone in the audience who would like to make a comment, please come to the microphone, identify yourself, and let us know what you have to say.
So, my name is Myrna Walsh, 280 Autumn Avenue. I'm directly across. Before I start, I just want to offer a compliment to Lauren, who was exceptional, really great customer service, and amazingly called me back when she said she was going to. The board needs to know that.
We know she's
We
special.
do. She keeps
Well-
us upright and taking nourishment on a
Yeah,
regular basis.
now on the public record. So I'm not speaking against this or for it. I just had some questions, and I think with my questions answered, I would endorse it. I'm just a little confused because I thought that the permit was for one client at a time, but then tonight I heard 2 clients, and I think there's just one room, but that's not my call to make. My call is really about the parking because there are 2 clients at a time. Potentially there's coming and a going, so there potentially could be 4 cars, and I just want to make sure that folks are parked in the driveway because it's a extraordinarily blind curve. And if they park on the curve, cars coming the other direction on Autumn Avenue wouldn't see them. So just that there was, it was clarity that there was space there. I wasn't sure that I heard or know what the hours of operation are. I'm not sure that is part of what the board decides or I'm not sure if that's part of your purview, but I'm interested in hearing that. And I just had another question, which is, my sense is that, and I could be wrong, Christina, but that this is part of a franchise. Is Upward Spiral an organization that exists outside of you guys?
Absolutely not.
Okay, because on the website, it did, for Upward Spiral, which could have been, who knows, in Akron, Ohio, it did say that they were offering outside classes and outside groups and multiple groups. So that's not you people at all. I shouldn't ask them, I should ask you, I'm sorry.
Yes, and I think that what I'm hearing from the applicant is that this is a one-location operation. It is not part of a franchise or multiple.
Not part of the franchise, and we are considering having an office in Hingham, but that doesn't have anything to do with this, and it is not a franchise.
Yeah, so just having, so I guess I would endorse this with the one question about how many people would be seen at a time, and then how many cars would be there.
In hours of operation, you also ask
That's
for.
true, that's true. Yeah, but otherwise I would endorse it with those questions.
Sure. If the applicant would like to address those questions for us, that would be great.
Sure. So we have an extraordinarily big driveway that can actually accommodate, I'd say, at least 6 cars, if not more. But that being said, in the application, it does stipulate 2 people at a time. So that is for couples therapy. And so what I would like to propose is that there will be no more than 2 cars in addition to our own. And our driveway is more than sufficient to provide that parking. As far as hours of operation, I think that Carter and I would agree that hours of operation should be more or less along the lines of business with an expansion of 1 hour on either side, meaning 8 a.m. to 6 p.m. Is that acceptable to you?
Do I have a choice?
Well, you're my closest neighbor, and I value our friendship, and I'd like to create this with your blessing, so.
I bless you.
Okay. So I think that that is suitable to me. And Carter, do you agree with those hours? Okay.
The hours, I forgot. I didn't hear.
Monday through Friday or weekend hours as
Well,
well?
may I have your permission for Saturday?
I think you need to if you're going to get couples.
Thank you. Yeah, that would be great.
Yeah.
Yeah.
So Monday through Saturday, 8 to 6.
Yes, sir.
Okay, thank you.
I guess, if I may, Mr. Chairman,
Please.
I would maybe consider a condition that cars have to be parked in the driveway.
Yeah, I was thinking that too, and that we condition the hours as well.
Yep.
Operating hours.
Yep.
Okay.
I'm a little concerned about the driveway. It appears to me so, according to the plan, driveway is 46 feet long.
No, sir.
20 feet long.
Do you have the photographs of the dwelling? Does it show that in there? I think.
I think he's working off of the plot
I
plan.
understand, but the photographs of the dwelling, the actual photographs, does that include the driveway? Because we are the previous owners of the Duxbury chimney sweep, and so we had the driveway widened, so it goes beyond the span of the garage by another car width, if that makes sense to you. So the driveway is actually 3 car widths wide and 3 car lengths deep. So from the garage to the edge of the street, you can fit 3 cars.
So
Does that make sense?
Yeah, the trailer that we see here, that's coming this way to the left of the garage, so that's part of the third.
Yes,
Third,
there's
okay.
more than ample
Yep.
room.
And that trailer is on pavement, it's not on the lawn?
Yes, sir.
Okay.
Yeah. So even with the trailer there, you could fit 7 cars.
I also heard a few minutes ago that, it's kind of a blind curve in the road, and if people are gonna be coming and going every hour or 2 hours or whatever the time period it is, are they backing out into the street? Or is there enough room
Yes,
to
it's
turn
no-
around?
It's no different than what we do on a daily basis.
Yeah, but you don't do it every hour, do you?
Sometimes.
It just seems to me to make a lot more sense to create turnarounds, the cars and turnarounds, they don't have to back out in the street. Is it a blind corner on this street?
It is not a blind corner.
Well, hey,
And it's not a blind corner, and people don't go screaming around the corner. I find it unnecessary to request a turnaround. Plus, well, anyway.
273.
100 feet from the driveway or something.
Which direction is the corner from, if I'm standing in your driveway looking at the street, right or left?
To the
To
right.
the right.
Okay? And is it, you have a neighbor who abuts you? It
On the
looks-
other side of that
There's our-
curve.
And that's Myrna. who's here.
Well, no, the abutting neighbor is on the other side.
Well, maybe you
The
could,
opposite
if
side.
you took a look at this plot plan.
Sure.
So are these 3 buildings on your property as well, or is that the neighbor?
This is the curve that they are referring to.
Okay,
The
so
abutting neighbor is here.
the curve begins beyond your property.
Yes.
Yeah.
Okay, so then that, by this
I
plot
can show
plan,
you also
Freeman,
on the phone from the, from
I
the
know-
maps
I
or
know where you
whatever.
If you turn
Oh,
around.
there you go.
by this plot plan, Freeman, it looks like the curve begins
Yes.
Oh, sorry.
This
at a
is our
minimum
house
of
here.
180 or
I am
maybe
capable of
200
doing
feet. Oh, there it is on the
Sorry.
wall.
Yes, this is the
Sorry about
house.
that. I didn't even notice.
This is the driveway.
Perfect the way it is.
So it's a gradual.
Yeah.
It looks kind of blind with all the vegetation in both directions.
Could I say something?
Sure, come back to the microphone, please.
Okay, so. So here's what I'm going to suggest.
Well, hey, if you could take the microphone with you, we have to be very
Oh, my.
cognizant of keeping people in TV land.
So I'm Taylor Swift, I am not.
No
But
songs?
I could be. Okay, so here's what, I don't think we need they need a turnaround. I don't think there's space for it, but the only thought is the cars should not park here because there is a lot of vegetation. So cars can park in here, cars can park on here, on the grass, you can park your own cars on the grass, and cars could even park here if they needed to, although that's not ideal. The thing is, you don't want cars parking here because when you're coming in this direction, if a car's coming wide, which has happened, and there's a pole right here, there's no room for this car going in this direction to go around them. So there's enough room here in the driveway, I believe. And they can park their cars on the grass, or people could park here. Does that answer the, does that?
Well, I think the intent is to not allow cars parking on the street.
Exactly. But this was, when I was speaking about the curve, this is really, even though it's sort of gradual, it is impossible to see because of Carl's trees. Carl O'Neill's farm is here. So I don't think there's going to be a problem so long as people don't park on the street.
I don't either. They were short, it's 1 or 2 cars, and they can back onto the lawn and turn around
Yeah,
and go.
exactly.
Without putting way more pavement that they've already got.
Thank you, Emmett, because the point I wanted to make is if people back out here like this, there's plenty of view coming this way. If they go across, they still have a little bit of space. So it is a blind curve only if people park here. Does that, am I?
That provides us with some clarity, yes, thank
Okay.
you.
You want a song?
Sure, go right ahead.
No, you don't.
Haven't seen that happen yet, so it might be interesting.
It's the first time for everything, Jim.
What do you mean? We've had song and dances here.
That's true.
All righty, let's do this.
She's got the screen, I think.
Would anyone like to make a motion to close the public hearing, or before I say that, does anyone on the board have any further questions for the applicant?
There you go.
Hi, Phil, this is Boris. I had one question. I'm not familiar with the state agency that oversees this part of the health facility, or the board of health didn't have any comment, but do we need to hear from the state agency that they have any comment, or is there some sort of inspection of the premises that is suitable to handle this type of activity or business? Do we need to have any information on that?
I don't know, I guess that's a question for the applicant, Boris. It looks like Tracy Mayo's comment was that that massage therapy is licensed by the State Department of Public Health, but she didn't go into greater detail than that. Perhaps the applicant can answer your question better.
I cannot, because I don't know.
So, could I answer? Because Lauren was so helpful. It is,
Sure.
It's the
But
state license.
again, I hate to do it, but
Oh, sorry.
you're going to have to go back to the microphone.
Sorry.
My God, it's getting warm in here.
Sorry. Again, thank you, Lauren. There's the state licensed massage people, masseuses, and if there is a complaint, it's handled in a similar way that medical complaints are through the Board of Registration of Massage Therapy. And they can inspect, the state can inspect at any time during business hours without prior notice if there is an issue.
But it sounds like from what the applicant has said, there's no requirement for a pre-inspection of any
No.
sort. Okay. Boris, does that answer your question?
Yes, it does, thank you.
Okay. Well, now I think we could entertain a motion to close the public hearing.
So moved.
Do we have a second?
Second.
All in favor? Aye, Phil.
I am it.
Hey, Tanya.
I Freeman.
Hi, Boris.
I, Wayne.
All right, very good. Is there any discussion amongst board members? Or would we like to entertain a motion to approve the special permit with the conditions discussed, i.e. no parking on the street, no sign, and hours of operation 8 a.m. to 6 p.m. Monday through Saturday? Does that cover it, Amy? Did I get them all?
You did. Thank you, yep.
Second.
I'm still uncomfortable with the backing out into the street.
We closed the hearing, Freeman.
Yeah. Yeah, you closed.
Yeah, I think we've closed the hearing though, Freeman.
But he's entitled to discuss the.
Well, oh, right.
Okay,
Yeah,
okay.
Member, and therefore I can speak. I can speak because I'm a board member.
I apologize.
You haven't,
I don't think anybody made a motion yet, have they?
No.
Hammett seconded Phil's suggestion.
Yeah, mine
Oh,
was just
okay.
a suggestion.
Okay.
I'm still uncomfortable with people potentially backing out of this driveway and getting T-boned by a car going northbound on a map. I would feel a lot more comfortable if somebody like Jim were to go take a look at it. Maybe we make it conditional upon him feeling as though it's safe backing out, but I don't want to vote to approve this without that issue addressed.
I can address that because I have been out to the property a few times in the past, and it's actually a pretty clear sight line from that property. There's not a lot of shrubbery on the lawn. There's none, actually. Once you turn that corner, it's a really clear sight line and pretty good distance before their driveway.
Okay.
Freeman, if it makes you feel better, I was out to the site for the previous homeowners, and I backed my truck out, swung out and left, no problem.
Okay. We'll let it go then. I just heard the neighbors say it was a line and corner, sharp corner and stuff, but if you guys say it's safe, then I'll go with that. I'll make a motion to approve the special permit with the conditions so mentioned.
Second,
All in favor? Aye, Phil.
I am it.
I, Wayne,
I, Freeman.
Horace.
Hey, Tanya.
I'm interested in.
It's unanimous. You have your special permit. Congratulations and best of luck with your new business venture.
Thank you.
All right, moving right along. The next matters before us are the continuation of two public hearings. And Amy, how do we need to, do we need to handle these individually? I don't recall if we handled them individually or at the same time when we opened the hearing.
You opened them at the same time at the last
Okay.
meeting. So
Okay.
you can just open up both the 0 Toby Garden Street appeal and the 0 Toby Garden Street variance request.
As Amy just said, we are reopening case number 2023-21 and 2023-22, Bell Point LLC, 0 Toby Garden Street, an appeal and a variance. Since our last meeting, we have, sitting on this case are Wayne Dennison, Tanya Trevisan, myself, and Boris Goyniech.
Mr. Chair,
Yes,
may I just mention Emmett Sheehan did file a Mullen affidavit. He watched the previous meeting.
oh, terrific.
So-
Welcome to the club. We do have some new materials that have been submitted since the hearing was opened. We have an application for a building permit dated June 12th, 1972, where Oceanside Realty Trust applied for a permit on, it appears to be the parcel to the north of the current Toby Garden Street. The second item we have appears to be a determination from county commissioners regarding the subdivision of this property, if I'm not mistaken. And I think that is all that we've received additionally. Yes, Lauren?
That's correct.
Okay, thank you. Is our applicant here this evening or on the wall?
Phil, it looks like we also got a water department service connection card.
Oh, I don't have that, Wayne. Sorry.
It's on the back of,
Yeah, it's on the back.
Oh, is it on the back of the permit?
yeah.
Oh, okay. Dated June 7th, 1972, Lot 20B, Toby Garden Street. I believe that's the, well, it's obvious that's the lot north of Toby Garden Street, since no one would be connecting water to something that doesn't exist to the south of it. there are some additional notes here as well that I believe are, if I'm not mistaken, they're attached to the permit application. So now, do we have an applicant here who would like to speak to the board? It appears that they're a no-show. Do we can we ask members of the public who are here with an interest in this to?
Yes,
Okay.
this was proper, I'm sorry, Amy Questle, Town Council. This was properly continued. As you might recall, it was essentially continued as a courtesy to the applicant because there were only 4 members here. At the last hearing, we did discuss the appeal, we did discuss the variance, there was a straw poll taken, and the applicant had the ability to submit further information and come back. And the information that's been submitted was submitted by the town. Lauren and Jim found that information. So I don't think the applicant has submitted anything, nothing. So I think you can move forward tonight with a vote.
All right.
It is a public hearing still. It is still
Okay.
open. Yep.
Well, before we do that, if there are any members of the public who are either here in the room this evening or on the wall that would like to speak about this matter, please identify yourself and speak away. Yes, sir.
Yes, I spoke at the last meeting. My name is Patrick Stout. I'm at 283 Old Toby Garden Street. And we're the direct abutters. If you look at your, if you have a plot plan, we're sort of the, we're 020004. So I had a few things to clarify that from the last meeting. And I noticed that I didn't know if you had sort of a listing of the previous transactions when it was initially sold to Joel White, and the applicant had said something on his initial thing about that it was years after being sold by the original owner. It was that the northern part of the lot was built on, and that's what your permit application was on, right? But it was actually 1 year. From the assessor's office, I had the DiLorenzos sold the land to Joel White for $6,300 in February 23rd, 1971. And the house, I assume, was built in 72. It was sold in March of 73 for almost $36,000 to Thomas and Mary Murphy. And it's been sold a number of times. And actually, so I don't know what the $6,300 would be in today's dollars, considering the value of land now. And in that area where we are, an acre is around $500,000 in terms of tax valuation. So they sold. I assumed that they had sold the whole parcel, both parts. So I was rather surprised when the DiLorenzos were still involved with that little triangular piece, which, by the way, is one of only three. There's 4 lots in our little area, and as you pointed out the last time, or actually maybe Wayne did. That the other piece of the lot is also a triangle, and also 020001, which is right down from us, is also a triangle. So he was trying to go on about some sort of uniqueness of the lot, the shape of it. But at any rate, so I was a little surprised that for 50 years the DiLorenzos were still apparently paying taxes on the lot in question. It didn't make any sense, especially since in the application to build that house, that it didn't, one of the notations was that the town took into account that the parcel had been separated by eminent domain and had been They took that into account when they granted the permit, apparently. Is that what you have in front of you?
What, back in 72?
Yeah, in that application, for the permit.
The detail is rather limited for what went on in 1972.
Yeah, I know. Well, yes, it's kind of murky. I had more questions than answers, but anyway, I do know that one of our other abutters, who unfortunately had to go to a wake tonight, Stephen and Nicole Bates, I believe he sent an email in opposition to this as well. But anyway, the applicant had. Did you get that? I think he sent it today.
I'm sorry about that. Yes, I do. It came in, let me see, it might
Late
be
this
here.
afternoon,
He and I played phone tag. He wasn't able to attend the original meeting
meant to
because
read that.
they had a family vacation up. They were off skiing. It's a tough life. But I know he had wanted to put his 2 cents in about it. So anyway, I was just kind of curious, as we've been living where we are now for 40 years, and in all those years, the Di Lorenzos were never in evidence. They never approached us if they had wanted to sell that piece, that if they still owned it. It's just kind of, I thought it was kind of odd in general, but they did make money off it, so it wasn't any kind of hardship so far as the applicant had been claiming. And Joel White spent about $2,200 or $22,000, but sold the house for $36,000. So he made money too. So I just thought it was odd that they didn't unload both parts of the lot at the same time, unless that maybe was a conveyance error, but I don't know about that either. Like I say, I had more questions than answers. The only problem I would have, other than the fact that it's only 1/3 of an acre and a very poorly, should we say, shaped lot to build a house on, the only hardship would be that, and I did say this to somebody when they first asked me about it. I said, well, we'd have to move, because we bought the place in the first place because of its location. We had cranberry bogs across the street, pumping station down the hill from us, and this unbuildable lot. And by the way, when we had the first hearing, Tag Carpenter had said when he was a kid living right down the street.
I lived across the street, so I
Were you there?
8 Sampson Street, my parents built that house.
Okay, were you there like in '72 though?
Yeah. I don't recall the details of 72, but I was there.
Okay. Well, he had said when he was 6 years old that there was common knowledge in the neighborhood that they allowed the house to be built because of the fact that it had been separated, and they took both parts into account. But we also had heard that from Mary Lally. I'm afraid it's the late Mary Lally. She lived right at the corner of Sampson and Toby Garden. It's the very next lot. It abuts it directly. And she had told us the same thing. So had the unfortunately recently deceased James Deneen, who lived right down the street from it as well. Although I think he moved there a year or two after it was built, but he had heard that. So I think that verbal or oral memory is probably accurate, but I wasn't there then. We came 10 years after it was built, as far as that house goes. So anyway, the people who actually live in that house now, that was built, the Gambinos, and I don't think they've been in communication with the board, but I believe they winter in Florida, so they're not even around right now. So I'm not sure what, and I actually don't know them, to tell you the truth. So I'm not of a lot of help, but I just wanted to mention those few things that I know that the Gambinos are paying taxes on a fairly modest house, and the valuation I think is somewhere in the mid 700,000s. So I kind of thought that would include the full parcel of land for their tax bill to be that high. I mean, for their valuation to be that high. We have almost an acre, and we're not valued that high. So,
Well, after you just said that publicly, I'm sure they'll give you a jingle maybe.
we've already talked. I said, they jacked it up $1,000 last year on us, so. And I went and asked, not Jamie, but Scott, Scott showed me the map of, he said, we live in the district of town that went up almost 35% last year because of all the new houses, all the new $2 million houses built over on Elm Street. And so we're included in that little area. Can you change that? That's too bad. But anyway, so that,
So you're opposed to it, we get that now.
oh, God,
All
yes.
right.
I mean, I thought, you know, if I were trying to make a quick buck on real estate investment, I would have thought that lot was a real long shot. I mean, there's got to be, you know, things that are closer to being buildable than that one. I don't know. But that's all I've got. But thank you for your time.
Thank you. Good evening.
Thank you, Mr. Chairman. Amy McNabb, I'm a member of your select board, but I am not here in that capacity. I'm speaking as a resident who lives at 269 Old Toby Garden, so just a couple parcels away. And I'm going to probably repeat the same things from the last hearing, which is, I think, you know, we're going to see more and more of these efforts to try to develop every last parcel that can, you know, in town, because it is so profitable. And I think that pressure is going to only worsen as time goes by. And I think we have to all, you know, toe the line here. What has become clear in doing a little bit of research, and some of the, again, Lauren's been super helpful, is that I don't know if you can see this, but it's so easy to see that this is the parcel that has the house now. This is the parcel in question, and here's the road that they put in. The roadway, if you look back in the documents that Lauren distributed, that roadway taking was about 11,500 feet. The parcel that has the home is 0.4, and the parcel that is in question tonight is 0.3. All that made the 1 acre parcel before it was split by the road. In 1972, when Joel White obtained the building permit, he made the building permit speaks to the fact that the 2 lots, which back then were being referenced as 20B and 20C, on both sides of the road. So I think the language here supports what the conversation was at the last hearing and what Tad Carpenter confirmed, which was that when the building permit was obtained, the building department looked at the totality of the 2 parcels that were separated along with the road, along with 11,000 square feet. And they said, okay, you had it back a few years ago, you had the 40,000 square feet, we're gonna give you a building permit. It was probably the right call. I don't think it was anticipated that the parcels would have not retained the same ownership. I think that what happened was the house got built on the 1 parcel, and then when the property was conveyed, nobody wants the little dog leg across the street. It's just junk. You're just gonna pay taxes on worthless land. So I think it was just a conveyance issue, and what we're seeing is an attempt to get a second bite at the apple. And I don't think you get that. I think it would be a tragedy if that were to be the case for a lot of parcels in town. And if in 1972 there was an error and that the building department shouldn't have issued a building permit, well, that's still no reason to continue to make another error and do it for this parcel too. I don't think that's the case, and I'm not suggesting that, but I'm just saying that, again, I think that this would be, it's a terrible lot, it's a tough location, you have roadways, you have parts of that parcel that aren't going to be able to count towards your square footage because of the way our bylaw is written, and you can't count those little tips of the triangle. So it's problematic in so many ways, and the detriment to the Stouts. I mean, it would be the only place to put a house would be right up against that lot line. It's just I think it fails on many levels, and I thank you for your time and consideration.
Thank you. Yes, of course, Mr. Stout. Sure.
I didn't, what Amy just said was, I hadn't addressed that. Our house is literally about 15 feet from from that property line. So if they were gonna build a house, it would literally be on top of us. And I don't.
Well, they'd have to keep the 15 off of there, so it'd be 30.
Well, I don't think they could build if you did that. I mean, that's part, I think that was one of the variances there were several variances.
Right.
And and I don't know how, I like to say, I don't know why that was a parcel that he was trying to pursue. And I also don't know, since he was trying to portray it as a hardship for the De Lorenzos, they don't seem to be in evidence at all. I don't know if they're even involved or, the other thing is, and I think that the email from Stephen Bates addressed the speeding factors. And I did mention this last time, but I know there's a few other people. The joke between my wife started this, but some of the police officers who clock people on the road, we call it the Toby Garden Speedway because you're coming out of Tinkertown on a curve, and then there's a fairly long straightaway, and people go up to 50, 60 miles an hour up there. And that's right where that house would be situated, right at that tip. And because of the angle coming the other way onto Old Toby Garden from Toby Garden, it's a diagonal, and people rip down there. And I know actually you lost a dog on years ago, and we've been very fortunate. We haven't had any kids or people walking their dogs right near the top of the road getting whacked. It's been it's kind of an unsafe area, to say the least. So anyway, that's all I wanted to stick back in there. Thank you.
Thank you. I guess before we go any further, I should probably read this. Mr. Stout reminded me of it. The email from Mr. Stephen Bates, who I believe is an abutter. To the Zoning Board of Appeals, as an abutter to the proposed development, I would like to weigh in on 0 Toby Garden Street. We would have liked to have been there in person, but we were out of town on the date of the initial hearing and unfortunately had to wake this evening. That said, just want to put our objection on the record, really due to the lot's proximity to the intersection of Toby Garden Street. As a 16-year resident of 197 Old Toby Garden Street, with our driveway on Old Toby Garden, I can't tell you how many times we've had close calls exiting our driveway due to quick turns at speed coming from Toby Garden onto Old Toby Garden. Another property I feel would only exacerbate the problem, let alone this being a safety issue for a resident exiting a driveway of the proposed property. Please let me know if you need further information from me. Hope to be at future hearings if warranted. Thank you for your consideration. Stephen Bates, 197 Old Toby Garden Street. And that, I think, is everything we've received. Are there any further comments from the public? I don't see anyone on the wall that appears to be raising a hand. Amy, you have?
So, yes, thank you, Mr. Chairman. Amy Questle, Town Council. I was just going to suggest that you vote on the appeal first, and then vote on the variance second in separate votes.
Okay.
Because they are separate case numbers.
So we close the public hearing separately.
We close the public hearing before we take either of those votes.
Yep, definitely.
Okay, that's what was confusing me.
And you're closing both public hearings.
We can close both public hearings at the same time, but then have to vote.
But vote
individually.
separately, correct.
Very
Thank
good.
you.
Bill, sorry, this is Boris. Before we do that, could I just ask one question, maybe to Jim?
Please do.
The let's just say, Jim, you got two streets here, you got a triangular shape, obviously. Normally, you need 20 feet off of each one of those streets, is that right?
Potentially 25 feet, depending on the
25 feet,
road
okay.
layout,
So
if the
let's
road,
say 50 feet deep.
correct.
What would be the minimum size dwelling, the dimensions of a minimum size dwelling? In any web depth or length? What
They're
would-
asking for
for a-
variances.
As far as building code goes,
You could build a tiny one.
there isn't one. There's minimum room dimensions
Okay.
of 70 square feet and 7 by 10, but there's no
Okay.
minimum dimension for a house.
Forrest, they were insisting that they could build a one-bedroom house.
Yeah.
Yeah, I know what they thought, but I was just hoping to see that on paper, just to see what that would look like. But that's okay, I'm just a question, thank you.
It doesn't meet any of the dimensional requirements. I would deny this all day long like I did.
All right, well, hearing no further comments from the public in the room or on the wall, I think it's time for us to have someone it's time to entertain a motion to close the public
I
hearing.
move to close all public hearings.
Second, Emmett.
All in favor? Aye, Phil.
Aye, Emmett.
Aye, Boris.
I wait.
All right. Public hearings are closed. Discussion amongst board members. I have a couple of thoughts. Number one is that it appears to me in the research that I did with the materials that were presented that, yes, at one time there was one lot here that was bisected when the road street layout was changed. And it appears from what limited information we have in the public record that a building permit was issued for one parcel. And my thought was that based on the tax assessment for the parcel that we're discussing tonight, based on what the assessment was, it looks to me as if it was considered to be land that wasn't buildable since the beginning of time, so, or not since the beginning of time, but since 1972. So I don't see how that suddenly makes it buildable.
So, Mr. Chairman, if I may, with regard to the appeal, they have argued that they can enjoy the separate lot exemption, which is General Laws, Chapter 48, Section 6, Paragraph 4, Sentence 1. And it's my opinion that they are not able to enjoy that exemption because this lot was not made non-conforming by a zoning change. It was made non-conforming by a taking. And so therefore, in my opinion, their appeal should be denied as they do not enjoy the exemption of the separate lot protection.
And quite frankly, my recollection is that the applicant acknowledged that it was not in fact a grandfathered lot. But I agree with Amy's analysis. So I'm going to move that the appeal be denied on the grounds that that the lot does not enjoy the protection of the separate lot under the applicable statute, and that it is not a grandfathered lot, and therefore it is not, that Jim's denial of the building permit is appropriate.
I would second that motion.
All in favor? Aye, Phil.
Aye, Emmett.
Hey, Boris.
I wait.
So you need to do that.
So that's unanimous.
Right, so
So,
that is unanimous. Now we have the second item, which is the variance, the second case, which is
Yes.
the variance.
So with respect to the variance, we have a high standard here to issue a variance. We're gonna have to show, they're gonna have to show that circumstances relating to the soil conditions, shape, or to topography of the land or structures affecting that property specifically, and a literal enforcement would be a hardship. And then on top of that, they have to show that the relief they're asking for won't be a substantial detriment to the public good. I will acknowledge that it's a strange shaped lot, but it's not the only strange shaped lot in the area. They didn't put any evidence in at all with respect to the soil condition of the topography. And frankly, I cannot get beyond the requirement that there needs to be showing that there won't be a substantial detriment to the public good, because given the location of the roadways and the fact that every neighbor who showed up was adamantly opposed to it, it seems to me to be a significant derogation from the public good. So I would move to deny the request for a variance.
Do we have a second?
I will second that, Emmett.
All in favor of denying the request for the variance? Aye, Phil.
I, Emmett.
I believe that was an aye, Boris. I believe it's unanimous.
Did Wayne vote? Wayne did not vote.
I did.
Wayne
Thank you.
voted.
Oh, thank you,
Yep.
sorry, Wayne.
I voted in favor of my own motion.
Great, thank you.
It would be odd if you hadn't.
You never know.
Right. All right, so the next item on our agenda tonight, the final item on our agenda tonight is case number 2024-01. The Board of Appeals will hold a public hearing in the Mural Room, 878 Tremont Street, and via Zoom on Thursday, February 8th, to consider the application of Charles J. Husk, care of Christopher J. Davidson, Esquire, for an appeal under Article 900, Section 906.1 of the Duxbury Protective Bylaw. The property is located at 160 Marshall Street, parcel number 122-082-000 of the Duxbury Assessor's Map, consisting of 7.6 acres in the Residential Compatibility District, Flood Hazard Area Overlay District, and the Wetlands Protection Overlay District, and owned by Charles J. Husk, care of Husk Management Company and 160 Marshall LLC. The applicants request the Board of Appeals overturn the zoning enforcement officer's removal order issued on November 29, 2023, which required the removal of 2 accessory structures and utility lines within the Wetlands Protection Overlay District. The applicant claims that the violations cited by the removal order have been remedied and the issues are now moot. The application may be viewed on the town's website under the Zoning Board of Appeals page. Pursuant to Chapter 2 of the Acts of 2023, this meeting will be conducted in person and as a courtesy via remote means in accordance with applicable law. If the technology fails, it's not our fault. You can also watch us on Verizon Channel 39 or Comcast Channel 9. Submitted documents include an application for the appeal, a background document. Do I need to read the entire background document, counsel?
Who's it from?
I believe it's from the applicant as part of the application.
They can present it.
Okay,
The applicant's here.
all right, very good, thank you. Exhibit 1 is the zoning violation removal order, signed by Mr. Wozlewski, Director of Municipal Services. Do I need to read that entire? Would you recommend that I do?
Yes.
Okay.
Yes, it's what's being appealed.
Okay.
That makes sense.
Zoning violation removal order dated November 29th, 2023, addressed to Charles J. Husk and Jennifer Bilo, owners of the property. Dear Mr. Husk and Ms. Bilo, on November 27th, 2023, the Town of Duxbury Zoning Board of Appeals held a public hearing on the June 29, 2023 applications of Charles Husk, applicant, for a special permit pursuant to the protective zoning bylaw of the Town of Duxbury. The zoning bylaw, sections 404.6, 404.8, 404.9, and 906.2 for the placement of 2 accessory structures, former trailers, in the Wetlands Protection Overlay District. While the plan you submitted dated November 15th, 2023 from Webby Consulting shows only 1 accessory structure within the WPOD excuse me, you testified that both accessory structures are serviced by utilities and each contains a sink and shower, and therefore utility lines would have been placed within the Wetlands Protection Overlay District and without a special permit in violation of the zoning bylaw section 404.6. The board voted unanimously to deny the applications. As a result of that decision, I'm hereby serving you with this removal order for zoning violations at 160 Marshall Street. You're hereby notified that you're in violation of the zoning bylaw by having an accessory structure within the Wetlands Protection Overlay District without a special permit and having utilities connected to both accessory structures without a special permit. Therefore, I'm ordering that the 2 accessory structures be removed from the property within 10 business days from receipt of this notice. Further, the town reserves its right to seek judicial intervention for the removal of the unpermitted structures. Thank you for your anticipated cooperation. Signed, James Wazalewski, Director of Municipal Services.
What was the date on that?
November 29th.
Thank you.
The next document is a zoning permit granted to Mr. Husk on October 14th, 2021, for the construction of 2 accessory structures. Each are 190 square feet. This is, I should clarify, this is a Town of Duxbury building permit. Correct, Jim? That's an accurate description of it? No? Okay, I'm glad I asked. It's a zoning permit. It says zoning permit, yes, sorry. Construction of 2 accessory structures, each are 190 square feet. The placement of the utility building must maintain the 15-foot side and rear setback and 25 feet from the front. Per Board of Health, structure not to be placed on septic components. And then the next,
Who issues those? Is that you?
We do, yeah, I do.
yeah, that's Jim's signature on there. The next item is the, this is our decision, number 2023-02. The applicants, William and Jennifer Rice, Carl and Joanne Coons, Karsten Bose, and Manny and Karen Weiss. This is the appeal of the zoning enforcement officer's decision to deny the request for enforcement. This is included with the, I don't think I need to read that entire thing. Thank you. Exhibit 4 is a plot plan.
I'm sorry to interrupt, Mr. Chair.
Yes, go ahead, Tanya.
I'm sorry to interrupt. I have a question for our counsel. So I'm not sure whether the Rices and the others are represented by Attorney Udy in this matter or have been, but I work with Attorney Udy, so I need to know if I need to recuse myself or if I'm okay.
You need to recuse yourself.
Okay, thank you.
Yep.
I'm doing that now. Have a good night.
You too. The next item is a plot plan of the subject property, 160 Marshall Street. Next is a memo from the Planning Board dated January 23rd. At the meeting of the Planning Board on January 22nd, the board voted unanimously 4-0. Mr. Udy abstained to defer judgment on the appeal application for 160 Marshall Street, ZBA case 2024-01, to the Zoning Board of Appeals without additional comments. The next item is a memo from Tracy Mayo, health agent. There is no change in the comments of the Board of Health in regards to the accessory structures from September 2023. See comment below. The Board of Health will require the septic system to be upgraded to a Title V compliant system in accordance with its February 17, 2023 decision that the system be upgraded in a shorter period of time set forth in Title V to accommodate the existing house and any proposed buildings prior to the Board of Health signing off on a building permit. Next, we have a memo from Nancy Rufo, Conservation Administrator, dated January 26th. I've reviewed the appeal of the zoning enforcement officer's removal order issued on 11/29/2023 and offer the following comments. It is unclear if the current location of the accessory structures is under conservation jurisdiction, since the resource areas have not been professionally delineated. To remedy this, the applicant filed an abbreviated notice of a resource area delineation on December 13th, 2023. The public hearing for this application opened on January 9th, 2024, and is currently continued to February 13th, 2024, pending peer review. Second, there are open orders under DEP file number SE 18-1971 related to the location of the structures. Mr. Husk requested to relocate one structure under these orders, which were described in the original filing as, quote, sheds on movable trailers, unquote. Installation and/or removal of utility lines is not part of this filing. And third, future conservation action, including filing requirements, will be determined once an order of resource area delineation is issued by the Conservation Commission. Thank you for the opportunity to provide comments, and please contact me if you have any questions. And I believe that that is all we have.
Sorry, Mr. Chair, we did receive an updated site/plot plan today that's in front of you.
Okay, so I guess it's time for us to hear from the applicant.
Good evening, members of the board. I know the letter was submitted by Chris Davidson, but just by way of introduction, my name is Brennan Cook. I represent the owners of 160, 162 Marshall Street as well. So I know the board's been aware of this case through various matters that have come before it, but I'll give some brief procedural background just to refresh the board's memory as to how we got here. Mr. Husk began working with or Mr. Wazalewski, the building inspector, excuse me, it's late, in October of 2021 to construct and permit this structure. In September of 2023, I believe, there was an enforcement request, September of 2022, there was an enforcement request to Mr. Wazalewski that covered a couple different topics at the property, and one of them were these trailers, the bungalows, which were described as trailers in the enforcement request. There was a hearing held before the board on January 26, 2023, that addressed that issue. In that finding, they determined that the believed location of the bungalows were in the Wetland Protection Overlay District and required a special permit based on that. They also found that the structures had the wheels attached to them or removed, and as a result, they were found to be accessory structures. And then in November of 2023, Mr. Husk submitted his application for a special permit for the two bungalows as depicted at the plan that's attached, as I believe you said it was Exhibit 4, to our letter that was submitted for this hearing. That special permit application was denied, and 2 days later that was issued from Mr. Wazalewski was in order to remove both the structures, one, based on the fact that it was located in the WPOD and didn't have a special permit, and two, based on the fact that there was testimony indicating there were utility lines running to both bungalows that were not special permitted as well. Subsequent to that hearing, one of the bungalows the one bungalow that was located in the Wetland Protection Overlay District has been moved, and the utility lines have been removed from both of them, so there's no hookups going to the bungalows as they sit today. And the plot plan that was submitted today shows the current situation as built on the property and the location of the two bungalows in relation to, it's tough to see, but that thicker dotted line is the Wetland Protection Overlay District boundary. So we are requesting that the enforcement order from Mr. Wazalewski be overturned on the fact that it was essentially ordering excessive relief. The order itself asked that the bungalows be removed completely from the property. And as demonstrated by the plan that's been submitted, as well as the work that's been done at the property, both of them exist there as accessory structures outside of the Wetland Protection Overlay District. And the utilities have been removed, so there's no longer a special permit requirement for either of the structures. I believe the memo we submitted covered most of the arguments we had, so I will keep the introduction brief and see if the board has any questions for the applicant.
Mr. Chairman, I just wanted to clarify one thing. Did he say the utility lines have been moved or removed?
Removed, sorry.
Could you tell us where they were originally? Where did they go? Where did they hook? Where did they originally come into the property?
It's not delineated on the plot plan.
Right, it's not.
I'm not sure exactly where they came in through, but there's no longer any utility lines there that exist in the WPOD.
How were those removed?
By the applicant,
How?
by picking them up from the ground.
They were above ground? They were not underground? They
I'm
weren't
not
in the-
entirely sure where they were located. CJ, were they underground? Yeah, they were above ground, so it was an easy removal process.
Is that all you have? Wasn't
Yeah,
sure
like I
if you were
said,
continuing.
we cover the arguments in the letter that was submitted to the board. You know, I think that covers it, you know, pretty squarely. I'm not sure if the board has any questions for.
Mr. Chairman, I do have another clarification question. What is the yellow line on the plan? I can see the red lines are the W pod. I don't know what the yellow line, if that's the coastal bank. I'm not really sure what that is. The yellow line that goes up the,
Could be, but why
Where's
doesn't it
north?
shift? Why doesn't it go to the left as well?
yeah, exactly. It goes, I don't see a north arrow. Okay, so it goes up the easterly side of the whole property. What is that?
And then ends at the point.
Yep.
No, there doesn't appear to be any reference to it.
I can't find one. I looked this afternoon, I looked again. I looked quite a bit. I can't find one. I mean, I guess it's top of coastal bank. That's the only thing. So if you look above accessory structures, it says top of coastal bank is delineated by Goddard, but there's nothing, it's not pointing to anything. I'm not sure if that's the yellow. I don't know.
I don't know.
Okay.
And I know through Conservation's work, they are still working with Mr. Husk to delineate the resource areas of the property. So that's an ongoing process. There was a plan submitted by the Husks, and I believe the Conservation Commission is seeking their own plan as well to show the resource areas.
Yeah, there was reference in their memo to they're waiting for peer review. Yeah, please, come to the microphone, CJ.
Yeah. Charles Husk, 160, 162. Yeah, Leanne just came out Tuesday to look at it, and there was some discussion about coastal banks and that kind of stuff.
Leanne is.
Lenore.
Lenore.
He means
Excuse
Lenore.
me, Lenore. Was the consultant hired by the Conservation Commission.
Oh,
So
okay.
she just came out, and we were actually having some interesting discussions about that coastal bank. So I'm interested to get back with her again to, we're going to reflag it and talk about it again, because, yeah.
But
so.
is that the yellow line? Is that what that's?
I'm
Is that
trying
what
to
you
figure out
think?
You guys are talking about this yellow line situation here.
Can you see it on the?
Yeah, look at, is it
Yeah,
there?
you can see it on the
I
plan.
think that's where he had, where Tom from Goddard initially put the, where he initially flagged the coastal bank.
Okay.
But we had, again, Lenore and I, we had a different discussion about that, which is
Okay.
kind of interesting. So that might move, actually. I gotta get back with her again.
Okay.
But, so that, like.
So it has no meaning right now?
It doesn't. If it's the coastal
Nor the
bank, it
red
doesn't
line.
matter to us.
Well, the red line.
Right, the red lines matter to us.
For your purposes, as it states in the bylaws, talking about the WPOD, that's what is marked in the red, so I wouldn't you don't want to dive into conservation stuff too much. We'll be here for a long time.
Yeah, so if the board looks at the updated plan, if you scroll down for me there, the bottom there delineates the current location of the 2 bungalows on the property, and that red line delineates the edge of the Wetlands Protection Overlay District. So as you can see, the structures have been moved out of the Wetland Protection Overlay District. As I said, the utility lines that did run to them have been removed, and as they currently sit, they're accessory structures allowed under the bylaw in an RC district on the property. So there's no basis for a special permit request, and that's the essentially the claim that the building inspector's order was overly broad in ordering that they be removed from the property entirely.
So just as clarification, the utilities that were there were water and electricity, and those are no longer, that neither structure is connected to water or electricity at this point.
There was electricity running to the bungalows, but the water was never hooked up. There was never any water that ran through the system there.
We were told at the last hearing that there was watering of pigs.
What?
Remember
No,
you watered your pigs?
No, I was talking about, chickens. Very different from pigs, and as you can see, the chicken area
They had
here.
water left.
I am aware
So
of the difference between chickens and pigs.
The idea was, in the future, what I wanted to, because I do also use these for agricultural purposes, put some of the water hookup that would go to that area as well. If permitted, we have to go through
Is this the chicken house or the pig house?
as Tracy, noted in her comments, that we have to do TJ. Oh, yeah, sorry about that. You can take it off. Oh, yeah. All right. We'll do the Kelsey thing. So, yeah, I was just noting in that comment that I would like to run, when allowed to, after the septic goes in, which is going to take some time. This is a complicated project for that. Again, this is a tricky area, so we're just trying to do it the right way. It's going to take some time to do that correctly. So, yeah, my intent was I want to put some water lines from there to there, but currently there isn't any. I physically bring the buckets over and fill their water, but it would be nice to have that.
Okay.
But that's a future thing.
Currently no electric or
Yeah,
or
currently
water.
no water, no electric.
Okay.
Jim,
Thank
may I ask you a question? Did conservation approve the construction or the placement of anything of these bungalows?
Yes, they did.
I can't speak to that. I don't know.
I'd love to see that.
I mean, we got this plan today.
Correct.
I have a question for Jim as well.
Sure.
Well, can we answer the other?
Jim?
Can we answer Emmett?
Hang on just a second. Wayne,
So-
why don't we let CJ and his counsel answer Emmett's question, and then
Sorry,
we'll
Wayne.
move to yours.
Yeah, I was in email contact with Nancy about that. We have, like Phil stated, we have the order of conditions open, and I emailed with Nancy, and it's about the movement of those of the structures. And initially, the whole of the conservation came out and had eyes on those in the first get-go of the whole thing. So they have seen that, the whole commission has seen that, but that was when Joe was on the, but the current committee has since been out for other orders and conditions. They've, we look at it and seen it, so they're aware. But Nancy, yeah, she okayed that. I made sure that was back and forth with Nancy, so. And that falls under the.
So there are no orders or conditions regarding specifically these guys, or?
No, there is. All right, sorry, you didn't understand that. Yeah, there's currently an open order of conditions that Phil just talked about.
Okay.
And she amended that order to allow me to move it, and it has to do with, so that there are an order of conditions for those structures. And if I need additional ones, I'll take that out with her. Yeah, happy to do that, so.
What did conservation give us? Any
Wayne's question?
What did they give us?
The only thing that conservation gave us was,
I just have one comment, I know that you were calling the record here, but we were first aware of these in a building zoning complaint that we received on October 19th, 2020. So it was prior to 2021, just to clear that up.
Sorry, the 2021 was reference to that.
again, I'm
The
sorry.
original complaint came in about many different things that were going on, and one of these were these structures that the complaint came in October 19th, 2020. Not 21, as he mentioned, was the first interaction with this. And the other, I do have a question for the applicant about this. There's a history here that is quite frustrating and has cost the town and taxpayers quite a bit of money. And the result of that is what you're dealing with now, and that you continue and have in the past. There's a big history of doing the work first and then dealing with the repercussions afterwards. And my question is, as you move forward these structures and plan to use them however intended to be, will you change your ways and actually permit them first?
So I believe it was covered at the last special permit hearing that they're under 200 square feet, so they're exempt from the building permit requirements.
Potentially. Because
Well,
in the last meeting, I think it was discovered that we saw some mini splits or something on these that haven't been completely verified, or some conditioning or an air conditioner. And subject to Massachusetts law, which is Chapter 143, Section 96, that the exemption only applies with exception to the specialized codes, which in this particular case, if they're going to be conditioned spaces, then a building permit would be needed because the energy code would now apply to these, as well as plumbing and electrical permits that have not been pulled on these units.
And well, that's why the electrical units, the electrical utilities have been removed, so that there is no heat or
Correct.
cooling to
Correct,
the
but prior to that,
buildings.
that was done.
We have electrical and plumbing permits for that.
I don't see one.
I think we submitted it, but we do. They are in there. We should have, they do exist, we do have those.
They're there.
Those do exist.
So regardless of that,
That's part of the requirements, so like you were commenting, Jim, like you were saying, we were going through that process of the zoning permit.
there is a permit for underground 100 amp service for those units.
So again, that's been removed because of the proceeding for the special permit hearing.
But you just said it was on the ground.
Yeah, it's like just under the, like, not, it's just on the ground. Like,
It's on the ground, not underground.
well, it's like just subsurface, just like, right? Not like just
There was
right
an underground
at the
100
top
amp
of the-
service installed and inspected there, according to the application and the permit and the inspection report.
Yeah, it's just
And it's been removed.
there, yeah, we took it out.
So the underground service was removed.
Yeah.
Yes. Yeah, there are no utilities.
So,
needed
I
to
had a
the-
question, I had a question for Jim, if it's an appropriate time, Mr. Chair, to ask the question.
Please do.
So it's my understanding that even if the structure is under 200 square feet, you still need a zoning permit.
Correct.
And a zone permit requires a site plan that depicts the area in which you want to install the less than 200 square foot structure, and at least some outline as to what the foundation is. Are either of those supplied relative to the new locations for these structures?
All I have is the new plan that we received today.
The as-built, basically is what this is.
Essentially,
It's
they're
an
not- I
as-built.
don't think they're calling it an as-built, but all I have, Wayne, on that is the new
yeah.
plot plan that we received today. It's the first that I found out that they were relocated.
But you didn't issue a zoning permit?
We did,
that
yes.
permits these structures in the area in which they are now located?
No, not in this area.
Not in this area, no.
Well, I believe the zoning permit that was issued didn't reference an area at all, and
Well,
it didn't
zoning
reference the
permit has to
WPOD.
reference an area
Yeah, it
because you
requires a
have
site
to
plan.
depict you have to depict the structure on the site plan.
That's right.
So,
I'm going back to that, give me 1 second.
so yeah, like we said, we're going to, as Jim was asking before, we're going to update. We want to continue moving on with the zoning permit to keep that zoning permit in compliance. Once we get through this,
Until he gets it all squared away.
the idea is to get this order taken care of so we can continue working on the zoning permit and getting that finished up, because we were basically at the part where Jim was gonna come do the final inspection. And yeah, since we moved it, that's a good point, that we should update the location. And I'm not totally remember the zoning permit, but yeah, if that, I think I recollect that was part of it, and we would have to update that. But that would be part of the removal of this order, that we can continue, as Jim was asking, to do all the compliant stuff, and when the further compliance of that permitting and whatever else we need to do. So yeah, to answer your question, Jim, yeah, we're whatever else we need to do, we'll do. If you ask us to do something, we do it. You asked for stairs and whatnot, we've done that. So yeah, we're happy to
But you
do
haven't,
whatever we have to
you
do.
never removed the buildings, though. He asked you to do that.
Well, that's the purpose of this appeal, is that they're
I just-
accessory structures
I just-
as of right in the
No,
RC
it's-
district.
It's pertaining to building, that's pertaining to the building
Sure.
construction,
I'm-
not,
It's just a point I'm making.
yeah, that's.
I have a question
Just
for
to-
town
can I-
council, if
can I-
if I go right ahead, Jim.
Can I just comment just
Please.
on what I want to complete Wayne's question. Wayne, I do have a plot plan that was stamped and certified for the original zoning permit. What wasn't on there at the time, which is why we have this new plan, is the wetland protection overlay district wasn't delineated on that original plot plan, but we did have an original plot plan for these structures.
What's the green thing up top?
That was a deck.
Were on that original plot plan, were the proposed location of the structures as they are now situated depicted?
No.
Thank you.
You're welcome.
My question for town council is, are we just spinning our wheels here, Amy, until we have a determination from Concom about whether these structures are now in or out of the Wetlands Protection Overlay District? It seems to me that they're waiting on peer review of this plot plan. And until we determine that they're either in or out of the Wetlands Protection Overlay District, we don't have much to talk about.
So we did, I did receive an email from Lenore White of Wetland Strategies. She's the Conservation Commission peer reviewer. And she did lay out the issues with this plan, with the ANRAD plan, which is a different plan than this that we're looking at.
Okay.
It's a area of resource, or an abbreviated notice of area resource delineation. And she listed a lot of issues with the ANRAD plan, but none of them had to do with the WPOD. So the WPOD is delineated by elevations. And so what we have in front of us is we do have a plan stamped by Joe Webby, who is he's not a PE, he's a PLS. So we do have a stamped plan indicating the wetland protection overlay district boundary, and it follows an elevation line. So I think that we're okay with going off of this. Lenore had no comments about the wetland protection overlay district in her comments that we received today.
So I want to just go over the history just a little bit, because there was some background that was provided. But initially, I think in January of 2023, we voted, as the ZBA, to require the owners to receive a special permit for the two sheds because we thought they were in the WPOD. That decision was never appealed, and it's final. It's a final decision. The owner never appealed it. The owner then applied sometime later for a special permit for the structures within the WPOD, asked that they could withdraw one of the structures because it was outside the WPOD. This board never acted on the withdrawal request, but that permit was denied and never appealed. So that's a final determination. Then Jim issues an order consistent with what has already been a final determination of this board at this point. And we are now being asked to reverse Jim's order because it's inconsistent with the facts on the ground, irrespective of the facts on the ground have been determined through two separate decisions of this board, neither of which had been appealed. So I think from a procedural perspective, we're in a very interesting place, and I do have a sense of how I would cut through the murk here, but but if there's other input that people would like to make relative to the fact that we've had two decisions that were never appealed, and what we're now dealing with is an order consistent with two decisions that have never been appealed, I think that's all we're doing right now.
Mm-hmm. Well, I would respond to that. Just the first decision was based on a belief that both structures were in the WPOD, and then the plot plan that was submitted with the special permit application showed that one of them was outside of it. The special permit application was denied, and the order to remove was based on the fact that there were two utilities running to each of the bungalows and one structure inside the WPOD that didn't have a special permit. Based on the plot plan that's been submitted that's showing the conditions on the property right now, the utilities have been removed and both structures are outside of the WPOD, which removes that special permit requirement. So to deny it based on previous decisions, it would almost be like the board changing the boundaries of the zoning laws or the zoning boundaries without following the procedural formalities. I mean, you can't require a special permit for structures that are inside the RC district, not the WPOD.
You can't appeal decisions that are more than 20 days old.
This isn't an appeal.
I actually have a way to cut through the murk here and to actually cut to the chase. I actually agree that if the structures have been moved and the utilities, however they were supplied, overground, underground, through the air, however they came there, if they've been removed from the WPOD and the structures have been removed from the WPOD, I agree that the order is moot. That it does not mean that we will overturn the order. It means that the applicant has complied with that portion of the order that required the removal from the WPOD. The portion of the order that the applicant indicates is excessive, which is removal from the property, I believe we should uphold as well, because there is no existing zoning permit for the new locations of the structures. So frankly, I would simply uphold the building inspector's order to remove the structures from the property unless and until there is a zoning permit that permits the structures on the property.
I want to clarify that the order is based on, it's not based on that there's no zoning permit. It's based on that there's no special permit for the WPOD.
Yes.
There's no
but
mention of the
way
zoning
that
permit.
This applicant chose to address the order was to not take the structures off the property, but instead to set them somewhere else. Wherever the applicant then chose to set them requires a zoning permit, which the applicant does not have.
Well, one of the bungalows does have the zoning, it hasn't been moved, it's the same zoning permit.
Or did you, okay.
So there has to be one new zoning permit for the moved bungalow.
It's an excellent point, I'll do it right away.
How can we be sure
No.
that, yeah.
Phil, is there anybody else who wants to submit?
I could make comment about this only because I'm gonna do this from memory, from 2021, I believe it was. We issued a zoning permit, the structures were existing, so we were reactive in this situation again, right?
Oh, they were
So,
there?
They were there already, so.
Oh, I see, I wasn't,
In an effort to get them to a point of compliance, we looked at the structures, said they're under 200 square feet. We did not know they were gonna be conditioned at the time, and therefore felt as though they were exempt from a permit at that time. Now, this has been a moving target that has changed so many times over the years, and I'm not gonna go through that, Merck. But what happened was, the structures were placed, and what I recall was, I was asked to go out there somewhere after we issued a zoning permit, because conservation had determined that they were in the wrong location and needed to be moved. So they weren't actually, what I recall, and I have no way to figure this out, except for the certified plot plan I now have, I received today, that back then, if the existing zoning permit that was issued initially, if those structures are even in that same place, because conservation ordered them to be moved, which they were shifted back, I don't know how many feet, but that's what I recall of this scenario, so I don't have any accuracy to the existing zoning permit as to the location, current location.
oh, so your zoning permit, so that was after the fact?
Oh, yeah, it was
All right.
reactive. They were there already.
Oh, all right.
Yeah.
So the plot plan you received with that zoning permit showed the post-move
Proposed location.
location? Yes.
Just to clarify, at the last meeting, I showed where the moved location would be on the last time we had a meeting. I showed the proposed move location, and the current location is in that general area of where I proposed to move it. So I did notify this board and building inspection that I was going to do that. We didn't discuss that, but that was notified at the last meeting. And I'm sorry about, I would have gladly updated that zoning permit. So I did move that.
So just from the former plan from the last hearing, which I think was in November 27th, and then this plan, it's your accessory structure possible relocation spot is not the same as the relocation spot that the structure is in right now.
Yeah, so the plan that was submitted
It's
today.
definitely different. It's been shifted down and over to the west.
The plan that was submitted today shows them as they exist on the property.
Right, so what I'm
right now.
saying is they don't exist as they did, where he is correct. He did propose a structure, a relocation spot. It's not the same spot.
Yeah, it's not, I didn't claim that it was. I just said that was sort of a general area.
Yeah, it's in the general area.
Yeah, I just sort of in the general area. It was just a kind of a proposed move location.
Is there anyone else in the room or on the wall who would like to make comments?
So my name is David Udy. I'm counsel to a number of the neighbors. One thing I want to just correct in the record from my perspective, and I think the record will play this out. I'm not aware of any approval by the Conservation Commission to allow the movement of this structure, and the structure per the ANRAD plan that has been, the preliminary ANRAD plan that's been submitted to the Conservation Commission during this open public hearing that they're having, shows that the structures before the one was just moved are in protected resource areas or in flood zones that are protected. So it's basically like shifting one trailer from a protected area to another. And I would ask, to get permits to put structures on properties, I would assume that the Board of Health and the Conservation Commission have to approve of these permits. And per the notes that were submitted to you by both the Conservation Commission and the Board of Health, they both do not approve of these structures. The Board of Health has said repeatedly, and the Board of Health is being sued by the applicant for their decision that these structures have to be tied into a property-wide septic system that complies with Title V. And Conservation Commission has not issued an approval for these structures. And in fact, the ANRAD plan that they submitted to the commission shows that they're in a protected area. And the original order of conditions for these structures, if you look at it, says they were for proposed sheds. And so what was actually installed were not proposed sheds, they were trailers. You heard their counsel refer to them as trailers, and they have wheels on them as per the pictures that we've submitted to this board, and they were fully outfitted with utilities and sleeping quarters. They were not sheds. So I would say the applicant pulled a fast one on the Conservation Commission to secure a preliminary order of conditions asking for 2 sheds, and what actually got put in there were living quarters that they were using commercially. So I would say that even if a zoning permit is required, which is what's been talked about, the Conservation Commission and the Board of Health would have some say in that, and they've already told you that they don't approve of these structures. So based upon the balance of evidence, I think that the order from Mr. Wazalewski should be upheld. Thank you.
If I could just respond to a few of the points raised.
Of course.
First, the ongoing dispute with the Board of Health, it's not limited to the septic system that involves the 2 bungalows. It's a broader review based on the sale that occurred with the applicant's brother. So it's not as isolated as it's made to sound to be. And going off the furnished living space, that's a recognized use under the Duxbury bylaws. An accessory structure is defined explicitly as a structure that has a furnished living space that is not a dwelling unit. That is essentially what these structures are in the summer months. It's an outdoor space to enjoy the waterfront for the family. And in the remainder of the year, it's a storage area, which, I think is the quintessential accessory structure on a property. And just to refocus, again, the claim is that the order that was issued by Mr. Wazalewski, it's overly broad and just excessive of the legal authority he actually had, where he ordered them to be removed from the property. Again, where it's been demonstrated, and it's actually happened as shown on the plan, that the structures could be moved into the RC district where they're allowed as of right and be located there. And again, the applicant is going through the conservation process. He's working with the commission, just as he's willing to work with Mr. Wazalewski to get the zoning permit issued to get the property in the right space. It's a complicated property. There's a lot of overlay districts. There's a lot of issues there with resource areas, and we're getting to the point where it's in the proper space with everything that's there.
That's why, as Wayne's point is, you've got to draw plans, have them approved, then you get to put the thing there or move it there. And even this last time, that didn't occur. You moved it without permission. You put it in another spot. The zoning permit should have been updated.
Yeah, and like I said, we're
I
willing to
understand,
update
but
that zoning permit.
none of it ever occurs. In my book, we've been sitting up here many, 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 many times, but every time it doesn't occur.
It's a structure that's allowed as of right under the zoning bylaws. Again,
Yep.
the order was limited to the special permit from the Wetland Protection Overlay District. There was no mention of a zoning permit that needed to be issued in the order to remove the property.
We don't tell people what they have to do. We're not your advisors.
I'm not asking that the board do that.
Well, you just said we weren't told, right?
But what we're appealing is the order that there's no special permit for the Wetland Protection Overlay
well,
District,
I'm-
not that it doesn't have a zoning. There was no order that it doesn't have the proper zoning permit.
I'm good. They'll do something.
Again, that issue was determined in a decision of this board that was never appealed. And there is no basis upon which to reopen it through an appeal of an order that's consistent with this board's decision that was never appealed.
I don't believe the zoning permit issue was decided.
I agree with you, because the issue is, you can't put in the structure without a zoning permit. There was an order that said, remove the thing from the property. The basis upon the order was, at least in part, because you didn't have a special permit under the WPOD. You didn't comply with that order. You dropped them somewhere else, and where you now dropped them isn't permitted either. At the end of the day, I'm gonna be very candid with you. I would simply uphold Jim's order in every respect. And if you want a zoning permit, go apply for a zoning permit. But I'm certainly not gonna overturn the building inspector's order.
I agree with Wayne. I'm on the exact same page.
I think it's probably time that we entertain a motion to close the public hearing, unless there's someone else in the audience or on the wall that has new information that they'd like to present.
I move to close the public hearing.
Second, Emmett.
All in favor? Aye, Phil.
I, Wayne.
I, Maura.
I, Emmett.
Unanimous. Public hearing is closed. Any discussion amongst board members? I mean, I'm in agreement with Wayne. He made a very clear points that we're sort of, it's almost like our hands are tied here.
Yeah, I would move that we uphold the building inspector's order for the removal of the structures from the property.
I would second that motion.
All in favor? Aye, Phil.
I, Emmett.
I, Maura. There it is.
Unanimous.
I, Maura.
Yes. Emmett seconded. Then the vote is unanimous to uphold the building inspector's order.
Do we have minutes?
I don't know, Lauren, do we have minutes tonight? I didn't see that on the agenda.
It is. We just have one set of minutes from December 14th, 2023, where, actually, it was just Emmett Sheehan, Tanya Trevisan, and Boris Voynich, so we can save them for our next meeting, because Tanya's not here.
All right,
So no minutes.
all right. Entertain a motion to adjourn?
Second.
So moved, Emmett.
Night.
Second, Wayne, to adjourn?
Yeah, I'm in favor.
All in favor? Aye.